Welcome back to Constitution Actually, where we review the U.S. Constitution and other writings. Day 20, Marbury versus Madison. The court's greatest power isn't in the Constitution. So the single most important power the Supreme Court has isn't written anywhere in the Constitution. The court gave it to itself in 1803 in a case it technically lost. The power is called judicial review. The Supreme Court's authority to strike down laws it finds unconstitutional. It's the thing that makes the court a genuine check on Congress and the president. And nowhere in Article 3 does the Constitution actually say the court can do it. Here's how it happened. In the last days of his presidency, John Adams appointed a batch of judges. One of them, William Marbury, never got his official paperwork delivered before Jefferson took office, and Jefferson's team refused to hand it over. Marbury sued to force delivery. Now, watch what Chief Justice John Marshall does, because it's brilliant. He rules that, yes, Marbury deserves his commission and the government was wrong to withhold it. But, and here's the move, he also rules that the specific law Marbury used to bring his case to the Supreme Court was itself unconstitutional. So the courts couldn't actually help him. Marbury lost. He never got the job. But in the process of denying him, Marshall established that the Supreme Court has the power to declare an act of Congress unconstitutional. He gave up a small battle to win the entire war. Jefferson couldn't even object. The court had ruled against the guy Jefferson opposed. It was a masterstroke. In one decision, the Supreme Court claimed the power to overrule Congress and the president. And it did it so cleverly that no one could fight back. Every major Supreme Court decision you've ever heard of rests on the power of court quietly handed itself in 1803. Tomorrow, the amendment that took a civil war and 600,000 lives to pass and ended slavery in a single sentence. Like and subscribe so you don't miss it.